So we just got some big news in one of the critical suppressor challenges that's currently pending in front of the Fifth Circuit en banc panel. The Trump administration, the DOJ, has just changed their position and agrees that suppressors are protected arms and cannot be outright banned. Now, this brief filed by the DOJ goes back on some of the prior arguments that they had made in this case and that they've kind of stood on for a very long time. So we need to talk about what happened in this brief and what happens now in this case going forward. Now, before we jump into this video, if you guys want to support the channel for free, please consider subscribing to the channel. That not only helps the channel to grow, but it tells the algorithm that you appreciate this type of 2A content. Also, just drop a positive comment down below because, again, that tells the algorithm that you appreciate 2A content and to share my video and other videos to you as well. Now, as I mentioned in the intro, in this video, we're going to be discussing a suppressor challenge that was ruled on by a 3-judge panel in the Fifth Circuit Court of Appeals at the beginning of this year, and currently this case is seeking Fifth Circuit en banc panel review. This case deals with the constitutionality of the NFA as it applies to suppressors, and the case we're going to be talking about is U.S. versus Peterson. In this case, Mr. Peterson challenged his conviction of violating the NFA based on a theory that the NFA and its suppressor restrictions are a violation of the Second Amendment. And on review, a 3-judge panel in the Fifth Circuit found that suppressors are not arms, and because of that, they do not trigger 2A protections. The prior administration litigated this case. The Biden administration was behind this, and they also argued, like they had traditionally argued, that suppressors are not protected arms, that they're simply accessories, that the NFA did not violate the Second Amendment, and these type of restrictions were permissible. However, now the Trump DOJ, through AG Bondi and the new 2A task force, they have stated in their new brief to the Fifth Circuit en banc panel that suppressors are arms and they cannot be outright banned under the Second Amendment. Now, like I said, this is kind of a mixed bag opinion and brief filed by the DOJ because at the same time, they argue that the NFA's restrictions do not amount to an outright ban and therefore it is consistent with the Second Amendment. They do, however, argue that the Fifth Circuit en banc panel should take this case and reverse what the 3-judge panel said in the Fifth Circuit about how suppressors are not protected arms and that they're simply non-necessary accoutrements. This signals a major shift in federal policy on how the federal government will now position itself going forward on this issue of suppressors. Here you have the DOJ saying that suppressors are protected arms, that an outright ban on protected arms is unconstitutional, and that they want the Fifth Circuit en banc panel to review this case and reverse what the lower court said. Now, in this case, back in 2022, both federal and state law enforcement officers executed warrants against Mr. Peterson at his home in Louisiana. He had a separate shop that he operated a gun store at, I believe kind of at the same address, but he had a separate shop. And that task force was ATF agents, including, I believe, 50 other law enforcement officers who came to his home. You know, they came with a warrant, they searched his home, and out of this whole incident, the thing that led to this lawsuit was the possession of a single solvent trap that I believe was within his home, and it was in a safe in his bedroom. In response to the charge that he was facing based on violating the NFA, Mr. Peterson filed a motion to dismiss the charge based on the Second Amendment. However, on review, that lower court denied the motion to dismiss the indictment, and that led Mr. Peterson to then appeal to the Fifth Circuit. On review, a 3-judge panel in the Fifth Circuit sided with the ATF in the prior Biden administration. In the ruling, the Fifth Circuit 3-judge panel stated that whether suppressors constitute arms is an issue of first impression in our circuit. Insofar as we can tell, every court to have addressed it has decided the question in the negative. Here, the Fifth Circuit looked at whether suppressors are weapons of offense or armors of defense, or are they used to cast at or strike at another? And the Fifth Circuit 3-judge panel incorrectly found that they are not. They stated that Mr. Peterson posits that suppressors are an integral part of a firearm and therefore warrant Second Amendment protection. They stated, however, that is wrong. A suppressor by itself is not a weapon. Without being attached to a firearm, it would not be of much use for self-defense. And unless a suppressor itself is thrown, it cannot be used to cast at or strike at another. And based on that, they upheld what the district court said. Now, that inherently was very concerning. It was a concerning decision, so Mr. Peterson and his counsel at this time decided to file for a rehearing en banc in the Fifth Circuit. In response, originally the DOJ, maybe some Biden administration holdovers, argued that a petition for the rehearing en banc should be denied, that the Fifth Circuit did not need to review this because the 3-judge panel got it right. In my prior videos, again, I told you that that was likely done by Biden administration holdovers and that the Trump administration and the AG's office was not aware of what was going on in this case. That has now been confirmed not only by the AG's office delaying this case, saying to the Fifth Circuit en banc panel that they potentially wanted to course correct because of the Trump executive order to protect the Second Amendment, but now we have this new brief filed by the DOJ, and it changes its position on whether suppressors are protected arms. In this new brief filed by the Trump administration and the Trump DOJ, they argue that as part of its broader evaluation of its litigating positions in Second Amendment cases, which they point then to the executive order to protect the Second Amendment rights, they state that the United States has reevaluated its position in this case. In the view of the United States, the Second Amendment protects firearms accessories and components such as suppressors. As a result, restrictions on the possession of suppressors burden the right to bear arms, and a ban on the possession of suppressors or other similar accessories would be unconstitutional. The government's earlier argument to the contrary was incorrect. So they're saying that the prior briefs filed maybe by Biden administration holdovers, that was wrong, and they are now reversing course. They state, however, that the National Firearms Act's registration and taxation requirement is constitutional because it imposes a modest burden on a firearm accessory that is consistent with the nation's historical tradition because suppressors are specifically adaptable to criminal misuse. For this reason, they state the panel correctly affirmed Peterson's conviction. Accordingly, although rehearing en banc is warranted, the court should grant panel rehearing to correct the panel's opinions analysis. So in the brief, the DOJ says that after reviewing this case, they are changing the initial position taken by the government before in this lawsuit. They argue and believe that the three-judge panel got some of the analysis wrong. They argue that suppressors are protected arms under the Second Amendment and cannot simply just be accessories. They also believe that an outright ban on the possession of suppressors would violate the Constitution. However, again, at the same time, they argue that the NFA does not amount to an outright ban, but instead the NFA includes permissible restrictions on the Second Amendment. On this issue of the NFA and its constitutionality, the DOJ argues that although the National Firearms Act's restrictions on suppressors' possession implicate the right to bear arms, the modest burden they impose does not violate the Second Amendment. Although a total ban on suppressors or other similar accessories would be unconstitutional, the Act's modest regulations pass muster. Now, when I read this brief, I think that the AG's office here and kind of the administration is trying to walk a fine line between arguing directly against the NFA and still presenting a case for the en banc panel here in the Fifth Circuit to grant review to this case. The goal of the DOJ with this brief may be to get the Fifth Circuit en banc panel to take this case and find that suppressors are protected arms, and maybe also as a result rule that the NFA's restrictions are a violation of the Second Amendment. The en banc panel here reviewing whether suppressors are protected arms and if an outright ban on these types of items is constitutional would still be a huge decision, since it would also create a much needed circuit split that would then create, again, a circuit split nationwide, because we've already had other circuit courts saying that suppressors are not protected arms, that the NFA is constitutional. So even on the issue of whether suppressors are protected arms, if the Fifth Circuit finds that they are protected arms, that creates a circuit split that then is really needed to get this case and this type of issue in front of the Supreme Court. So I wouldn't say this is the most pro-2A brief I've ever read, but instead maybe it's a little bit more strategic, and it's a strategic play by the DOJ and the 2A task force to get the en banc panel here to grant review to this case. Now you have both Mr. Peterson and the DOJ saying that the panel here should take review for at least the reason to reverse what the three-judge panel said down below and essentially reverse their finding that suppressors are not protected arms. Again, this is very interesting. It's an interesting shift in this case in just the policy at large, and that potentially means that 2A's task force is, making very significant moves to try to reverse anti-gun policies, even in very controversial cases like this one dealing with suppressors. I'm also interested to see if the DOJ's new stance on outright bans of suppressors and how that's unconstitutional will then lead them to file maybe briefs in the California and Illinois suppressor ban cases that are pending. It'd be very interesting to see if the DOJ decides to step in and argue that these statewide bans in states like California, Illinois, and others is also impermissible and violates the Second Amendment, because here in the brief, they're saying that they believe that that is unconstitutional. They also mention other accessories and other outright bans on other, items, and maybe that leads them to then jump in also on other issues like magazine bans, statewide magazine bans, and them saying that that is also impermissible. Now, time will tell, but at least in this case, you have both sides saying that the Fifth Circuit en banc panel must take up this critical suppressor case, and both sides are saying that suppressors are protected arms, and that the lower court here in the Fifth Circuit and also the district court got that analysis wrong. So again, big developments, an interesting shift of policy and arguments made by the DOJ, and that's what's currently going on in this critical suppressor challenge. I now, have more hope that the Fifth Circuit en banc panel will take this case. But even if they don't, that then opens the door to go to the Supreme Court, and then you would have the DOJ making similar arguments to the Supreme Court, saying that yes, suppressors are protected arms, and that the lower court got it wrong. So as it develops, as we get more information, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.